All right, next panel, session 2, Telehealth and Licensure Compacts Post-Dobbs. What's at stake? So given the nature of this panel, we just want to be really clear that CTeL's mission and priority is to address this issue of licensure. This is not going to be a debate on either pro-choice or pro-life. We're going to keep it neutral, specifically to the issue of licensure and the impact of Dobbs. And I also want to remind everyone to be respectful of each other's comments. All right, so welcome to, we'd like to welcome our panelists. We have David Alburn. He's the founder of the National Fingerprint Company. Carmel Shire, she's a JD MPH from Harvard Law School. Marshall Smith, Executive Director of the Interstate Medical Licensure Compact Commission. And Rick Masters, an attorney and CTeL Advisory Board member with the Interstate Medical Licensure Compact Commission. You will see below that we do not have a tabletop discussion for this session, but we do have 3 questions that we are going to be answering. So this is going to be more of a format where it's going to be more collaborative and conversational. All right, I'm going to hand it off to our moderator, Rick.
All right. And it's my pleasure to be here. I have been the counsel for the Interstate Medical Licensure Compact Commission since its inception over 5 years ago. I also have a similar advisory role with the Interstate Nurse Licensure Compact, and have been involved in this area of interstate compacts generally, not just occupational, but all things compact. For about 20 years, I was lead counsel with the Council of State Governments National Center for Interstate Compacts, and during that tenure also had the opportunity to participate in drafting the only legal treatise that's out there on interstate compacts, and it's called The Evolving Law and Use of Interstate Compacts. Catchy title, don't you think? And we have provided plenty of authorities on that subject, and so we are focusing on the licensure compact for physicians today. And as Krista said, we are not taking a position on one side or the other, but we are trying to explain how we've attempted to broker this problem through licensure, and each of the commentators have their points of view and information to share about how this process works. So I'm going to ask if Carmine would go first, and we'll move forward.
Sure. So I am thrilled to kick things off. I'm Carmel Shachar. I'm a professor of law at Harvard Law School, living out my legally blonde dreams. What I do at Harvard Law School is especially exciting because I run the Health Law and Policy Clinic, which is both a teaching clinic for students, but also very much a legal organization that provides regulatory advice, policy, strategy, and even in some cases, impact litigation to promote access to care, especially for medically vulnerable people and for lower income communities. In a separate thread of my career, for 6 years, I ran the Center for Bioethics at Harvard Law School. So if there is anybody who is equipped to talk about the smashing collision of reproductive rights and law and telehealth, I suppose that it is me. And in fact, for the last several years, I've been really looking at issues around telehealth, especially how do we promote it, because patients like it, physicians like it. It's generally considered a great way to extend access to care, especially for people who can find it challenging to access that care. But I also look at the increasing double bind that can be placed on physicians who are trying to provide quality medical care to their patients, but are uncertain of how to reconcile their professional obligations and the laws of their state, which I think is in part a big issue here because, you know, physicians want to provide care, but they also would like to, you know, not be subject to criminal investigation. They would like to not lose their licenses. And so people are very worried and nervous about what do I do here? And I think some of the challenge, and when I teach about Dobbs, the big point that I make to my students is that it's not that Dobbs just reverted us back to a pre-Roe America, because medical care has really dramatically changed since 1973. The way we get our care is simply different. And in part, that's the digital revolution. That's telehealth. That's allowing medical care to be more portable. Frankly, the ACA and all of the attendant litigation there really demonstrated that healthcare is increasingly national, although we still talk about it being regulated on a state level. And so because we're not in 1973, because medication abortion exists, because telehealth exists, it's really hard to say, okay, Texas is going to go one way, California is going to go the other way, and you guys just disengage, just like don't talk to each other about anything. That's the advice that I try to give my 4-year-old and 2-year-old, and it doesn't work. And I don't think that it's necessarily going to work in this case. And you see it because people really have a lot of weight on their opinions on this subject, much more so than most other areas of medical care. And so you see it in some states, like the Mississippi Attorney General saying that he has an eye on the fact that there are people traveling out of his state to receive abortion services, and that he thinks that Mississippi, because of the value that it holds on unborn life, has a right and an obligation to address this. And you see this, I am in Massachusetts, and I talk to a lot of physicians in Massachusetts who say, it is my professional obligation to provide these services to patients, and are pushing, say, like the Mass Medical Society to be very protective of physicians sitting in blue states who might be providing services to patients traveling out of state to them, or maybe through telehealth. So I think just saying disengaged, not helpful in my parenting, probably not helpful in this issue. And this is where I think the challenge to compacts are going to be. Because part of the whole idea of having the IMLC is that you have some sort of interconnectedness with the licensure. And what happens when states start kind of nibbling around that promise? And that could be in the case of shield laws that are popping up in places like Connecticut, like Massachusetts, like California, which try to put really almost an iron curtain, to use like a throwback metaphor, saying, okay, we are preventing our state actors from cooperating with any investigations in other states. And so another state might say, well, we have this compact, we're supposed to collaborate, and I need to investigate the conduct of a physician who happens to be sitting in Connecticut. And the state of Connecticut is preventing me from doing that. But you also see it, for example, Ohio has regulations saying that an Ohio license can be pulled for actions that occur outside of the jurisdiction of Ohio if they would be a felony in Ohio. And these are all going to be where sort of the pressure testing of the compact is going to be. And I think one thing to reflect there is, again, like, I'm somebody who holds professional licensure. I'm a lawyer. I have my bar in Massachusetts. I am also barred in New York, although I don't think I'll ever get to live out my Sex and the City dreams, only Legally Blonde dreams. And I understand how precious it is. Like, if I'm not a member of the Massachusetts bar, I can't do my job. I have a lot of debt from law school I'd like to pay off. I need to be able to use my licensure. But more so, I got my JD and I got barred so that I could help people, so that I could practice. And so telling physicians, okay, there's this interconnected web, it's kind of complicated, but at the end of the day, your state bar is going to have your back, and we're going to potentially just have to quickly reinstate your license and it's going to be fine. I think that's a really challenging message to provide physicians. I think physicians are going to say, okay, even if it gets automatically reinstated, the fact that like my license might need to be reinstated for actions that I take within this state that maybe trigger loss of licensure in a different state feels really unsatisfying. And those physicians might say, I need something more than that. And I think, like, I really like that Krista kind of kicked it off by saying, okay, let's talk about licensure. We're not here to kind of debate whether these services should be available. And I think it's always important to lead with the fact that this does elicit very strong emotions, and it's going to elicit very strong emotions in physicians who are providing these services, whether they're very committed to the reproductive justice movement, saying like, I need to provide these services to all patients who come through my door, or whether they are saying, I don't fully understand the life and health exceptions, which currently are being litigated in a variety of states, but I have a patient who has an ectopic pregnancy, and do I need to wait for her to become septic in order to use this exception? And nobody's telling me, and if I make the wrong choice, my license might be on the line. And so I think there's probably going to be a lot of movement there. It probably doesn't help that I think our Supreme Court is really in the midst of a quiet revolution on many fronts. So for my JDs in the room, the fact that the Supreme Court is kind of signaling that it's revisiting Chevron and how administrative agencies can interpret their foundational statutes feels as revolutionary as like Dobbs did. And we're in a moment where clearly they're rethinking right to privacy, which is the right to an abortion that was kind of foundational in Roe. But they're also giving signals about Chevron. They're giving signals in national pork producers about the Dormant Commerce Clause and how they're thinking about states relating to each other. So it's a lot of uncertainty, and it's really challenging to necessarily provide the kind of comfort and kindness that I think physicians are looking for as they get their modern medical practices and this kind of interrelated web and telehealth implicated in the abortion debate, which really has its own exceptional gravitational pull in America. So these things are hard. Hard things are worth doing, to quote Teddy Roosevelt, but there's a lot to figure out as we move forward.
Yes, for David Atterburn is our next panelist.
I am cursed. I'm a process engineer from the Air Force. I've been trying to live that down for decades because I'm married. And the problem is that we have to come up with procedures that really work for stuff that matters. We don't want bridges falling down, buildings keeling over, boats named Titanic sinking and stuff like that. That's bad. We don't want to have that happen. So I'm going to read a quick introduction because part of the curse is, as an engineer, if you ask me what time it is, I tell you how to build a watch. So to prevent that today, I've scripted my remarks to keep them short. So here it is. Last month, I accepted a CTeL assignment to explore telehealth licensure precautions after Dobbs. My companies use biometrics process patents to prove data authenticity and privacy compliance where multiple fingerprint criminal histories are needed. Last week, I attended the FSMB's Medical Board Legal Advisors Workshop. That's only like 4 days ago. And there I met Kevin Bonenblust, the Wyoming Executive Director who authored key notification clauses in Marshall's IMLC bylaws. His being there calmed the several sessions where telehealth licensing seemed jeopardized by states with opposite abortion laws. He patiently gave some private lessons to me in the hallways for 2 days on the difference between bulletproof legal drafting that triumphs in the end and the process discretion that member boards retain to individually determine how to deal with calls to impose an outsider's version of license limbo on telehealth providers. So I have some remarks about that when my turn comes up.
Then we have Marshall Smith, who's the Executive Director of the Interstate Medical Licensure Compact Commission.
So I was told I have 3.5 hours to talk to you about this issue, and I'll begin that right now. Actually, I always start off everything with a joke. So in a recent ice-breaking session of a meeting that I was at, everyone was asked to tell the one thing the craziest thing they ever did. And quite honestly, I was insulted that they thought I'd peaked already. So I didn't answer the question. So I'm the executive director with the Interstate Medical Licensure Compact Commission. This has been a key issue that the compact has dealt with since the Dobbs decision was issued. We issued a statement soon after the decision was brought down. It's been an issue, and it's been something that we've discussed as a commission, taking an apolitical view. The compact really has no position whether these sorts of services should or should not be provided. Those are certainly within the purview of each one of our member states as they do the practice of medicine. Our job is to get the physician the license so that they can practice and provide care to the patients in those states. And so, in a sense, we have two aspects to this, and I'm sure you can all appreciate the balancing act that we have to play as part of the compact. The first aspect is really all the good, positive things. I mean, we've processed in the first 9 months of this calendar year more applications, more licenses being issued, more licenses being renewed. Over 90%, 85 to 90% of the licenses obtained by physicians through the compact are renewed. So they're not just getting a license and going somewhere else, they're expanding their practices. We did in the first 9 months everything that we had done in the previous year. And the same thing happened the year before, and the same thing happened the year before. So I think when you look at it in our current environment, some of the information that came out of Dobbs and all of those sorts of things, the compact really is the strongest and the best option for physician portability. It is the way in our current legal and regulatory structure for physicians to quickly get licenses in multiple states so that they can practice across state lines. We get licenses issued to physicians in 7 to 10 days, calendar days, on average. We have some states that can issue the license in 48 hours. So there are all these really good things happening. And we have over 80,000 licenses have been issued through the compact process since 2017. We're trying to make it easier for physicians to use the compact. We just embarked on a multi-million-dollar project called the Enhanced Physician Portal that will give physicians a wallet where every single license they've ever held is in one place. All their continuing education is all in one place. So we're doing all of these good things. In 2022, 17% of all the licenses issued in the United States to physicians came through the process. The problem is we have this yabbit, which is a small furry animal with big ears. It's what happens on these other things. What happens when states start exploring their options and ideas of how they may be able to regulate physicians who are practicing in their state for things that they're doing in other states, and whether or not they have the authority to do that. We've put Mr. Masters and I have developed a paper, position paper for the compact, and we put given this out to you, and I'll talk to a couple points in that. And I also want to talk to how we handle discipline and investigative processes, some of the things the compact has done, all that. Oh, sorry, I missed a note. So back to the good side. If you look on our website, there was a study done by San Jose State University, Dr. Deo, that was done independent of the compact, and it was actually pretty surprising when we found out about it, and then they actually published it. This data study is called Access to Care and Physician Practice Growth After the IMLCC. They have found that the compact, just a state joining the compact, is twice as effective as all other measures a state might try to do. It's a third of all of the licenses obtained through the compact process are to serve rural and underserved areas. All of these things that we've thought and at the compact we've been talking about are now being supported by academic data. So back over to the Yabbit side. So we are sensitive to the needs and demands of each one of our member states. We have states that are on both sides of this issue. That our commissioners come together. We have these discussions, as was pointed out. Commissioner Bohenbless from Wyoming. We have commissioners from all of our states that deal with this. And we've looked at this issue, and we've looked at it from a regulatory point of view. The aspect about discipline is key and important to the compact. It is one of the most important public safety aspects of what the compact does. We've had instances where we have done a joint investigation of a physician who was sexually abusing their patients in multiple states. We were able to get that physician, and that physician has lost his license and is now currently in jail. And it was done in 3 months, a process that several states have been working on for multiple months to try to take care of it. So this is an important aspect, but it's not something that necessarily lends itself to allowing states to do something that they really should not or cannot have the authority to do, and that is to look at the practice of what a physician is doing legally in a state where they are providing those cares. And we've got a lot of this outlined in this letter, and I won't read it all to you, but I wanted to point out some very important aspects to that. And then I'll close by talking a little bit about how we do disciplinary processes, how the subpoenas and investigations work with the compact, and how we've actually strengthened the authority of each one of our member states to be able to do this. So oftentimes, joining the compact is the first time a state has codified the idea that the practice of medicine occurs where the patient is located at the time they receive care. It is one of the tenets of the compact. It's our first article, that's what the compact is about. And by implementing that, the compact, the states very strongly state that this is how they govern and regulate the practice of medicine of the state, and that's why they issue the license to that physician so that they can practice in that state. The other part is that there are foundational understandings expressed by the compact. This is on page 2 and 3 of the document, so I won't read it to you. You can read it yourself. But medical services provided to patients are controlled by the Practice Act of that state. The compact has nothing to do with the Practice Act of a state. We have to do with the licensure of that physician. And each state is therefore allowed to create how that license is used in that state. Even a cursory reading of the Dobbs decision clearly establishes that the opinion was intended to return to each state the power to decide how abortions should be regulated or prohibited subject to the above referenced federal constitutional limits. It actually, like it or not, Dobbs supports the idea of a compact and supports the compact solution to providing licensure in multi-state practice. And then finally, with regards to this paper, obviously I'm the executive director, and so you can say that I'm biased and all those sorts of things. But the reality is that a state who passes and joins the compact actually strengthens the protections for physicians in their states with regards to how their state intends to whether allow or prohibit women's health care issues. It's also a slippery slope. We're hearing a lot of discussions on other issues, gender-affirming care, opioid treatments that physicians could be doing. I mean, right now, the buzz is about Dobbs and abortion, but those other things are percolating there too, where states are considering, well, we have these very restrictive opioid laws. There may be a physician in another state who's also licensed here who is following that state's laws, and they are looser. Maybe we need to take action. Maybe we have a moral obligation to protect our citizens against a physician who practices in this other way in this other state. So it is an important issue, and it's broader than just I think the women's reproductive health care issues, and that is an important key part. But it is also a part of a bigger thing, and I know I'm running out of time, so I'll go quickly. So one of the other things I wanted to talk to is that the compact and our commissioners have been very diligent in ensuring that we are doing what we can to ensure confidence among physicians and yet provide the control that states need. Last year, in November of 2022, we passed Rule 6.6, and while it may not be perfect, it is about the best that we could do in creating a rule that allows states to look at the actions taken by another state to determine whether they choose to implement that same discipline or not, and whether they choose to take a physician's license or reinstate it. several of our states. It's in touch and in tune with the SHIELD laws, but it's also in touch and in tune with those states that feel that it's important for them to take the physician's license, and that other states recognize that. So we passed Rule 6.6, which was a very controversial and very long fought and important thing. But it does, again, put back to each state who issues that license the control over that license and how it's regulated and whether it should be taken. We just, in this, our most recent session, in our most recent meeting in November of 2023, we modified Rule 6.4, which is joint investigations and the subpoenas. What they have done is they pulled those generally broad subpoena powers and how investigations work and the mandatory requirements on member boards and put them under joint investigation. So they become mandatory for states if they are participating in a joint investigation. They are no longer just a general requirement that is out there. And we believe that that is, again, clarifying the importance of each state's ability to regulate, each state's ability to investigate, and each state's ability to discipline. To put this all in context, disciplinary matters, there is no central disciplinary group at the compact. When a disciplinary matter is addressed, it is provided to each state, and those states' investigative units under the control of their investigative departments, their AG's office, and all of those things then interact directly with each other. The compact steps out of it, except for in a communication role, but states then, it's done state to state. So again, states retain their control and their authority over that. And the last thing I will say is, while this is an important issue, and I certainly do agree that it's something that will be ongoing and continued discussion, there are over 16,000 physicians that have used the compact. We have 33 physicians that have been disciplined and have lost their compact privileges. That's a very, very, very small number. And so, yes, this is a big deal. Yes, it's important. Yes, the compact will continue to address it. But in context, I think we're doing it appropriately, we're acting responsibly, and we're taking the physician's interests and the patient's interest and trying to do the right thing. So thank you. I'm sorry I took too long. But Rick.
Thanks, Marshall. And as the lawyer for the commission and someone who's been involved in this area of interstate compacts, particularly occupational licensure in the last few years, I think it is a valuable tool to create uniformity and to resolve questions where uniformity is not possible. And one of the functions of interstate compacts is not only to provide a solution that is statutory in nature, because each state has to enact the statute, it also becomes a contractual obligation among the member states to follow what the compact requires, and it can be enforced in the courts if necessary. And there's three ways in which I think the Interstate Licensure Compact for medical practice promotes the ability to deal with the post-Dobbs world. We wrote the compact before Dobbs was decided. We had no idea that the Supreme Court, after we formed the Medical Licensure Compact Commission, would overrule 50 years of precedent in the area of reproductive rights. But fortunately, we wrote the compact in such a way that it actually responds, as Marshall said, to what the Supreme Court says it was trying to do, which in three different places, at least in the Dobbs decision, it says we're returning this issue to the states to decide whether abortion should be regulated or whether it should be prohibited. And so the compact reflects that value under the 10th Amendment for states to exercise their sovereignty rather than having to rely on a national standard. And frankly, under Dobbs, I don't think a national medical license is possible anymore because consensus can't be reached on what the scope of practice is in every state because we have differing points of view. And the compact permits and in fact requires that the scope of practice of medicine in each state is defined by that state. And that state also provides through the compact that treatment occurs where the patient is located at the time treatment is rendered. So the question has to be asked in every case, where was the patient located at the time the treatment was rendered? And whatever the scope of practice is in that state where the member state physician renders care is permitted according to the scope of practice, and one state cannot reach across a border and impose its scope of practice on another member state which has a different scope of practice. So we're not taking sides, but we are standing for the proposition that each state now has the right to decide what the practice of medicine will be in that state. And as long as the practitioner is aware of what that scope of practice is and abides by it, it provides a statutory protection in every state for that physician to do what the law allows. I think Justice Alito, prior to Dobbs, recognizes that other sections of the Constitution, such as the Commerce Clause, protects non-resident economic actors who are attempting to exercise their rights under the laws of other states. And he said in a decision prior to Dobbs with regard to the application of the Commerce Clause that regulations that discriminate against non-residents must be narrowly tailored to a legitimate legislative purpose. Well, how can it be a legitimate legislative purpose if you're trying to interfere with the scope of practice of a state that has acted pursuant to Dobbs to define what practice is and what it includes, including reproductive rights? 40 states, 40 jurisdictions have enacted the Medical Licensure Compact. It's not the only alternative, but it's the only legislation that I'm aware of that's actually been enacted and is in effect in that many jurisdictions. So there may be other solutions, but I haven't seen them, and somebody is going to have to work awfully hard to come up with a better one. So we are open for questions, I think, Krista.
No, we're not.
No, we're
I
not.
haven't given my talk yet.
Oh, all right. Did we want to do the tabletop discussion or? Okay, go ahead.
You just got to keep going, Rick.
I've been attending meetings mostly set up for and attended by other attorneys. For the International Association of Privacy Professionals in this town in April, 3,000 attorneys from all over the world and one process engineer attended for 4 really tough days. For the FSMB just a few days ago, all 90 attorney advisors for the medical boards convened in one spot to mostly agree with each other that there's a few gaps left to close. And so I'm going to give my report to Krista right now, the same way that my former military commander required that we captains give our reports. And they said simply, what we want to know is what, so what, and now what? So here's the what. I'm in the precautions business. From Air Force Days to prevent the SR-71 from taking blurry pictures to Homeland Security, including child abuse and its definition of terrorism, the approach to precautions and prevention always began with the same question, now used liberally by comedians and other stand-ups, and that question is, what could go wrong? In comedy, it's an unintended consequence, but in Post-Dobbs Telehealth, there's nothing amusing about it at all. What makes it extra difficult is to design practical precautions. That's the territory from which licensing threats arise, and it's the territory that's off limits to CTeL. In that unmentionable realm where appearance is reality, we may have to redefine some boundaries to assure CTeL doesn't give the appearance of moving beyond its own mission. But it's a fact. Licensure and the ability to practice can give the appearance of being jeopardized if some states' trigger laws are enforced and publicized. Do these appearances matter? Now we move on to the so what part. Telehealth providers' licenses can appear vulnerable when abortion-related practice occurs between polarized states. In that instance, one state's unintended consequence can be another state's intended consequence. Exactly what could be the purpose of licensure precautions in such cases? Tough question. One precaution's objective might be to blunt or dodge license suspension. That could take a lot of legal revision, and Marshall's December policy we're all holding clearly shows it's not necessary. So a different objective could be to blunt the appearance of a suspension. What would such a precaution like that look like? Well, already Kevin educated me that there exists 5 different forms of suspension among the states right now. Perhaps the compact could make a defensible recommendation for yet another more benign version of suspension. Now, question 1 on your agenda sheet for this session suggests 3 questions. So let's give the report on those questions the way my commander always wants to hear it. Here's the what on the first one. Some telehealth sessions, sir, between the states with opposite abortion laws are inhibiting providers' ability to practice. Oh, yeah? So what? Well, it's unfair. It jeopardizes patient health. It reduces access to care for the poor who need it most. It ruins medical careers in a time of shortage. And those unintended consequences continue for long periods while the legal decisions and appeals run their course to inevitably finally restore the ability to practice. Okay, now what? Well, devise means to temporarily arrange interim practicability, sir. Okay, next question. Oh, it's right on your list. It suggests this report. What? Some states' activists are mounting well-funded lobbying efforts to federalize their abortion stance. So what? Well, sir, it's legally hopeless, but the efforts confuse and mislead voters and patients into litmus testing providers' ideology, which interferes with both delivery and consumption of proper health care while opening doors wide to fraud on the poor. Okay, now what? Maybe you should form a constitutional team to proclaim the prohibition of providers to cooperate with such demands. Let them pull out their pockets and say, I'm not allowed to do this. Only one left. Question 3 suggests, what if we could maintain and expand telehealth compacts post-Dobbs? Maintain and expand the compacts post-Dobbs. All right, here's the what. Compacts are successful and are justified in wishing to federalize their preservation, protection, and viability. It's a good idea. Okay, so what? It's inefficient and too costly for each compact to devise and defend its own legal methodology. Okay, nothing left but the now what? Maybe CTeL should form and fund a legal team to gather best-of-breed aspects for model federal legislation. That's all, folks.
Questions? Yes, sir.
I got one question.
Do we need a mic or, okay.
It's not even on. Is that working now? There we go. Just one quick question. Oh, okay. Sorry about that. Does the IMLCC have any position or even just thinking about international telemedicine? I understand it's obviously an interstate compact, but does that ever come across your minds, and kind of how do you view that aspect of healthcare, right? Because I think a lot of times I have clients in other countries that are really thinking about taking care from the United States and delivering it to their countries where they have no very, very dissimilar kinds of regulatory schemes, and it makes it very challenging to sort of understand what their obligations are.
Right. One of the benefits of having been a co-author of a compact treatise is arcane questions like that actually were considered. The compact clause is a creature of the Constitution, and under the Constitution, the power of the states to enter into these agreements is recognized. Treaties would require authorization for our country and other countries to combine in such agreements. So while we could certainly craft a treaty, it would require congressional authorization for us to do that. And I think it's probably an idea whose time has come because of the global community that we all live in healthcare and other spheres. So it's a good idea, but we couldn't do it unilaterally without the help of Congress.
Mentioned, as I mentioned, I'm Tamara Perry, Children's Medical Center, Dallas, Texas. So we get a lot of border care in Texas. So as you are considering the international piece of it, Texas, we'd love to work with you in regard to the data of that. A majority of patients come across the lines for us, and we have to determine how care is given. And we never turn care away. Right. However, in Texas, there are laws against both, right? We had a Genesis clinic that was shut down for gender-affirming care. That particular physician has sued both hospitals there for not being able to provide care to their patients under this space. So it's a issue that Texas we're really grappling with, and would like more discussion.
All right. Mm-hmm. Thank you.
I just want to do a little stage setting as to why we even had this conversation. We got an emergency phone call from one of our CTeL members, and they said, I'm practicing in Ohio. I'm a primary care physician. I had a patient come to me with reproductive health concerns, and I provided them a response. I'm sorry, that patient was in Massachusetts. They're also, and the doctor was licensed in Massachusetts, and the patient, and they're also licensed in Ohio. So they were concerned that their license was going to be revoked from Ohio because Ohio has a law that says that if you essentially practice care in another state in a way that is non-compliant with Ohio's laws, you can lose your license in all the other states that are part of the compact. Right. And so they don't have, it's an unenforceable law. And so we need to understand that premise first. It's Ohio right now is trying to federal, if we understand the law correctly, Ohio, in this position, Ohio is trying to federalize their policy position to apply to all the other states. And as we know, that a state's authority only exists inside their boundaries. So we have a practitioner in Massachusetts seeing a Massachusetts patient that provided them legal care in that state for reproductive health issues. And their concern is, can I lose my license in Ohio because of a mailing that went out? So that's why we are hosting this panel now. And so just also to put in context of why this is important for all of you that are sitting in this room, many of you are coming from hospitals and health systems, and the pool of practitioners is quite small, even if you are using virtual care companies. Teladoc doctors, American Well doctors, you're all pulling from the same pool of clinicians, especially if you are in an urban or rural underserved area. So if you have clinicians that are losing their license, even if it's just temporarily and being reinstated through 6.6, there's going to be a bit of a lag time, and that's concerning. So what we want to do is have a very honest conversation about how is this going to impact clinical workforce shortages right now. So that's putting it in perspective for all of you that are in health systems and hospitals and wondering, well, why is CTeL even having this conversation? Okay, we're going to go here, here, and then here.
Thanks, Krista. That kind of gets exactly to my question is, I understand that some state boards have what I'll call follow-on disciplinary action. So if your license is disciplined in Idaho, you might then face action in Montana, Alabama, New York, wherever. So how does the understanding legally the compact says, you know, defer to state law, but then you have state laws that sort of have this follow on. Could you just sort of comment on how that plays out?
Let me take the legal part of that, and then I think Marshall probably has a logistical answer for that. The compact itself provides that all laws in a member state in conflict with the compact are superseded to the extent of the conflict. And among the laws that are provided in the compact is that the scope of practice in each state that is a member of the compact will be observed in that state and respected in a state that has a different definition of what medical practice is or a scope of practice. So Ohio, for example, is a member of the Medical Licensure Compact, and if a physician has obtained their license through the process of the interstate compact that Ohio is a member of, I don't see why that's not a defense to a conflicting action by the state. I don't represent Ohio, but I'll be interested to see if they go forward with any enforcement of any of these provisions, how that will shake out. Marshall?
So the practical way in which this disciplinary issue works is the fact that and it's divided into two parts. So if the action is taken by the state or principal license, and it's a taking of a license. So any other discipline, I'll talk to that in a second. But if a license is taken from a physician, suspended, emergency, whatever, and it's done by the state or principal license, all other states must place their license in that same status. Rule 6.6 says then they can undo that if they believe it to be appropriate. If the action is taken by a state that is not the state or principal license, then each state then places that license in a 90-day period of time in which they can investigate the matter and determine the action that they should take for their state. And again, 6.6 allows them to undo that quickly. It really is, I mean, from a practical, if you're looking at this from a non-Dobbs perspective, it makes a lot of sense. If you've got a physician who's losing their ability to practice in a state really should look at why that's happening. And so that's why it's there. The fear is that this might be used inappropriately. And these would be then manipulated for that. If a physician is disciplined by another state, their ability to use the compact process to renew is lost. And therefore, each state then must determine whether they will allow that license to be renewed through the traditional process or whether they will allow that license to not be renewed and require that the physician reapply. So that's the practical aspect of how this is, and you can then start to see, because you're all very intelligent people, how this might be used in a manner that it's not intended to be used. And so that's how the question came about, the concern by the physician who's licensed in Massachusetts and also in Ohio, how this might start impacting their licenses. And so, again, this is defined in statute. It's also in our Rule 6.0.
Hi, I'm Dana Northcraft. I run a nonprofit called RIGHTS, which stands for the Reproductive Health Initiative for Telehealth Equity and Solutions. And yeah, I work with a lot of abortion providers, especially in the telehealth space. And a lot of them are choosing to give up their licenses in states where abortion has been banned, or they've chosen to get licensed outside of the compact procedure. So I have a couple of questions. One is, like, I know you said that there were many more providers that were being licensed under the IMLC. I wonder if that's broken down by profession and if you're seeing fewer OBGYNs, or, because we know that physically doctors are leaving states or OBGYNs are leaving states where abortion is banned. And then also, I know there's concerns about not just Rule 6, but the initial charter, and if there are any changes you're considering to the initial charter that would allow for physicians to feel safer in practicing without fear of being disciplined if they have multiple state licenses under a compact.
Let me again point to the provision of the compact that says a member state whose law is in conflict with the compact is superseded. So, I mean, I think legally, it might have to be pushed to the point of a decision by a judge, but I don't think anyone who reads the language could mistake that that's the intent. Also, while we're not looking for a fight, we have responsibility not just to oversee the enforcement of the compact, but the Compact Commission has the authority to go into court if needed and seek injunctive relief and other relief if the compact's being violated. We're not on the warpath to do that, but if we get pulled into a situation where it's unavoidable, we have duties and responsibilities in that regard.
And to the question regarding the type of practice that a physician has to use the compact, we don't track that. So yeah, I would have no way to answer that question.
Yes, sir.
So it seems to me at issue is that, some states may see this as an opportunity to leverage 6.6 to expand their jurisdiction to the practice of medicine outside of their boundary. And so I wonder if the compact itself has put in safeguards on 6.6 that essentially the language is written in such a way that it ensures that their jurisdiction remains within their state.
Yeah, I think the provisions of the compact clearly provide that you can't use the compact to achieve a result that violates the scope of practice of another state. And I think we have clearly limited that so that the rule obviously can't be ultra vires vis-a-vis the compact. So I think we have checked that, but I don't think there's any mistake in the statutory language when it's reviewed that would allow that rule to be used in that way.
Could I have the mic, please?
Sorry.
Thanks, appreciate it. I mean, I think that some of it is, you can't let the perfect be the enemy of the good. I think one area where I could see things getting a little bit challenging is there are a lot of states that are kind of more battleground in nature when it comes to access to abortion services or gender affirming care or substance use treatment, for example. And there can be times where, a state flips. Like you see this, for example, Ohio or Michigan or Pennsylvania, where the laws on the books or constitutional amendments, it's a slow process. And so what I might worry with the need for the state board to go in and reinstate the license is what happens if there's a state in which, like, the laws on the books say, like, okay, we allow our physicians to provide these services, and then another state tries to use this kind of long arm language to say, oh no, they happen to be licensed in both states, they're providing abortion services in state A, we're gonna pull their license, which can technically trigger an issue with the license in state A, and the state board has shifted through appointments of various administrations to take kind of a different tact, and they say, okay, well, the license was pulled, and we'll just kind of let it go. Now, I don't think that's the most likely fact pattern. I think generally the state board would say, we feel very protective of our physicians. We want them to be able to practice. We're in a physician shortage, so let's take a protective posture. But again, I know from my physician colleagues and friends, they're very nervous about it. Whenever a license gets pulled, even if it's just a technicality and it's going to be reinstated, that's a really hard thing for them to go through. And I would never want to give the legal advice you're 100% good, because I just don't know everybody on the state boards now, and I don't know everybody who's going to be on the state boards in 5 years, 10 years, 20 years.
Good point.
We are over time right now.
Okay.
Thank you guys for this. Thank you guys for giving a wonderful presentation. Why don't we come back at 5 after, and we'll start our next panel. Will the next panelists come to the front?